big blow to the opposition. SC verdict on ED and PMLA provisions. The decaying opposition, in its frustration, seems to be going blind to provisions of the laws of the land. The country's apex court on Wednesday held the mirror up to the opposition on the constitutional position of powers of the Enforcement Directorate. What the opposition, be it the Congress, TMC, AAP, SP, RJD, NCP, Shiv Sena group led by Uddhav Thackeray, DMK, TRS or the CPM seem to forget is that no individual is above the law. And then the double standards of the opposition leaders become all too transparent. On one hand, they proclaim absolute faith in the judiciary and the law of the land, and on the other, they cry foul when their leaders are charged with misappropriation, accumulating unaccounted wealth, bribery, money laundering, and corruption. If the leaders charged on these counts are really innocent, the courts will set them free and their faith in judiciary will stand vindicated. What is the meaning of the protest when their leaders are charged with corruption? In its verdict, the three-judge bench of the Supreme Court upheld the ED's right to go ahead with an expansive definition of proceeds of crime, search and seizure, power of arrest, attachment of properties and tough bail conditions. In fact, those leaders, former Maharashtra Home Minister and senior NCP leader Anil Deshmukh and Congress Party's Karti Chidambaram, who challenged the provisions and even raised multiple issues, including one of the absences of procedure to commence investigation and summoning the accused without them being made aware of the contents of the Enforcement Case Information Report, that is the ECIR. To that, the court in its order made it abundantly clear that the ECIR cannot be equated to an FIR as it is an internal document of the Enforcement Directorate. It added that supplying ECIR is also not mandatory, yet a person can ask for records before a special court if continued imprisonment is necessary. The court also underlined that ED officers are not obligated to disclose the ground of arrest while detaining the accused in a money laundering case. What does it mean? None hereafter can cry foul that such action of the ED claiming it is violative of the constitutional guarantee of the right to liberty and right against self-incrimination under Articles 20 and 21. No whining anymore. Such an action of the ED cannot be construed as political vendetta. Against that backdrop, the Supreme Court verdict is bound to be a big blow to all those who are involved in corrupt practices. If anything, it may give sleepless nights to several politicians who are under the ED scanner. Leaders across the political spectrum find themselves in crosshairs of investigating agencies, and the law is bound to be equitable and impartial. Chidambaram has as much reason to worry as his party leaders, Sonia and Rahul. Satyendra Jain has as much cause for concern as Ajit Pawar. Officials like Sanjay Pandey, former Commissioner of Mumbai Police, and others will have to face the heat of the central investigating agencies and no longer have the impunity that they thought they enjoyed. Remember the Bollywood cliche, कानून के हाथ लंबे होते हैं. This is MS Purthy for Orange News 9 TV.